There and welcome to the Shaftesbury Society, the John Locke Foundation's weekly event, always focusing on an interesting topic, and we have another good one for you today. We see, hear, and read a lot about the United States Supreme Court and its interpretation of the U.S. Constitution. But most of us know much less about our state Supreme Court and the state Constitution. But that's a shame because the state's highest court and its governing document can have significant impacts on our lives. Our guest today offers us the following title for his presentation: Our State is Freer Than Yours: How State Constitutions and Supreme Courts Protect Liberty. Justin Pearson is the Florida Office Managing Attorney at the Institute for Justice. He also oversees IJ's national economic liberty efforts. Justin has devoted his career to defending the constitutional rights of small business owners, and he's argued on their behalf more than 100 times in trial and appellate courts across the nation. In several of his cases, Justin won constitutional arguments that had never prevailed before. Justin received his law degree with honors from the University of Miami and his bachelor's degree in business management, you'll like this part, from NC State. Not only did Justin go to school here, but he has successfully litigated constitutional challenges here too. These include a First Amendment challenge on behalf of a makeup artistry teacher in Charlotte. You might remember Carolina Journal reporting on that story when it happened, and a state constitutional challenge on behalf of food truck owners in Carolina Beach. And before I turn things over to Justin, I will remind you that we would love to take your questions if you will submit them at the John Locke Foundation's Facebook page, which you can find at facebook.com/John Locke Foundation, all run together, no hyphens, no capitalization. So let me turn over the virtual lectern to Justin Pearson of the Institute for Justice. Justin, welcome to the Shaftesbury Society.
Thanks, Mitch. I appreciate it. It's an honor to be here.
And tell us what you have to say about why some states are freer than others dealing with their Supreme Courts and constitutions.
I'm happy to, and I should start off by giving a little bit of background about myself. I have one of the greatest jobs in the world. I wake up every day and I sue the government. It's a lot of fun. I highly recommend it. I am a constitutional lawyer for a national public interest law firm named the Institute for Justice. What that means is I don't sue for money, and I never charge our clients anything. Instead, I spend my time going around the nation, convincing judges to throw out unconstitutional laws so that my clients can start their businesses or expand their businesses, things like that. And there's really no place better to do that than IJ. We're the nation's largest philosophically libertarian public interest law firm. We have almost 150 employees spread out among our 7 offices. And one reason why we're so large is because we've been tremendously successful over the years. We're getting ready to argue our 10th U.S. Supreme Court case. We've won almost all of them. And overall, we win over 70% of our cases, even though we look for the hardest cases that people say can't be won. Then we find ways to win them anyway. Now, IJ does a number of things, but I spend my time representing small business owners, typically fighting for something called economic liberty, which is the right to earn an honest living, free from arbitrary government interference. And so that doesn't mean that there can't be government regulations, but if the government's going to stop you from starting your business or pursuing your chosen occupation, they better have a darn good reason backed up by evidence, and it can't just be that they like your competitors more than they like you. And so because I spend so much time litigating over economic liberty, most of my cases are actually state constitutional cases, including one of the cases that Mitch mentioned. The case I brought in Carolina Beach on behalf of Michelle Rock and some other food truck owners. And that's not unusual. Like I said, most of my cases are state constitutional cases. And so it's really a shame that so often state constitutions are overlooked, because for many people, your state constitution may have a larger impact on your life than the federal constitution. So I'm going to talk to you briefly about what happened to Michelle, how the North Carolina Constitution helped me to help her out. And then we're going to talk about those general lessons and the things that I really wish more people understood about state constitutions. And so Michelle was a food truck owner in Eastern North Carolina. She wanted to operate in Carolina Beach, a beautiful town. I've enjoyed going there. I'm sure some of you have as well. And the town of Carolina Beach had no objection to food trucks. They just had an objection to competition. They said that the only people allowed to have food trucks in Carolina Beach were local brick and mortar restaurant owners. They didn't want, quote, outsiders. That was the word they used, outsiders, coming over the bridge and competing with local businesses. Michelle does not own a brick and mortar restaurant in Carolina Beach. Neither do the other people I represented who were food truck owners. And so we brought a case entirely under the state constitution, didn't even mention the federal constitution, in state court. And rather quickly, the state threw in the towel, capitulated, totally repealed the ban, and Michelle can operate her To-Go Boys food truck in Carolina Beach today. Now, in that situation, the town threw in the towel. I can tell you in other places, litigating under identical state constitutional provisions in other states, I've actually won in court where the state or the city or whomever has fought back, and we've literally won on behalf of food truck owners and other small business owners using provisions identical to the ones found in the North Carolina Constitution, which may be one reason why Carolina Beach threw in the towel so quickly, because we had such a stronger case under the North Carolina Constitution than we would have had in federal court under the U.S. Constitution. And so, before I dive into the North Carolina Constitution and state constitutional law, I know we have all sorts of different people watching this and in attendance with different backgrounds. And so I just want to make sure we're all up to speed and kind of starting from the same place regarding general constitutional law. First, just a quick primer. Constitutions provide the people's rules for their government. They represent the direct will of the people as opposed to just the will of the people's representatives. And while we're all required to follow the law, the government's supposed to follow the Constitution. A law that's passed that doesn't follow the Constitution is unenforceable. This was described repeatedly by the founders during the period when the U.S. Constitution was ratified. But perhaps the most famous description of this is when Alexander Hamilton talked about this in Federalist 78. If you haven't read the Federalist Papers, I recommend them, where he explained that when there's a conflict between a law and the Constitution ought to be preferred to the statute, the intention of the people to the intention of their agents. So basically, to make a long story short, if the government does something that violates the Constitution, you don't have to follow that law. And that's where I come in. I spend my time asking judges to rule laws unconstitutional and therefore unenforceable. Now, again, people constantly forget about their state constitutions. And one of the neat things about state constitutions is that they actually predate the U.S. Constitution. When the founders were drafting the U.S. Constitution, I think people like to think that they kind of came up with this all whole cloth. They actually did a ton of research. James Madison, in particular, did a ton of research. And one of the things that they looked at were the existing state constitutions, right? The 13 original state constitutions existed back when we had an Articles of Confederation, back before the U.S. Constitution was ratified. And much of the U.S. Constitution was literally copied and pasted from the from the state constitutions. And so, for example, the judicial power, most states had a state constitution saying that there was an independent judiciary that could rule laws unconstitutional. The framers of the U.S. Constitution just copied that. And they copied basically the first 8 amendments to the Bill of Rights, all taken from state constitutions. And it's also important, this is going to factor in quite a bit when talking about the relationship between state and federal constitutions, that it was understood that most of the regulation and most of the issues that most people would have in their day-to-day lives would be with their state governments. The federal government was supposed to be much smaller than it is today. And so things like that I like to fight about in terms of economic liberty and overregulation, those were really considered to be state issues where the federal government wouldn't be very involved. And so originally, it was really a state constitutional issue where every state constitution, including North Carolina, would include a litany of protections for economic liberty that just didn't need to be put in the U.S. Constitution because that was really a state and local government issue already covered by the existing state constitutions. So the state constitutions predated the U.S. Constitution. They were supposed to be your primary protection. The U.S. Constitution was supposed to deal with just a very small federal government, but things have changed. Now, before I get to how they've changed, I really would like to ask everyone here to do one thing after this talk is over, which is read the North Carolina Declaration of Rights. It's basically your state constitution's version of the Bill of Rights. It's at the very beginning, like in most states. It's the very first article of your state constitution, so it won't take you that long to read it. You don't have to read the whole state constitution if you don't want to and learn how to, create a municipality or something like that. But if you just read the first article, you'll find that there are all these wonderful protections that you never knew about that don't even exist in the U.S. Constitution. So please read Article 1 of the North Carolina Constitution. I think you're going to be blown away. And frankly, that's when I brought this case on behalf of Michelle involving food trucks, that's what I relied on, those protections in Article 1 of the North Carolina Constitution. And that's what I do in most of my cases, as I rely on the Declaration of Rights that exist in state constitutions as opposed to the U.S. Bill of Rights, as wonderful as that one is. So then what happened? Like, why do I sometimes bring cases under the U.S. Constitution? Why do you hear about the U.S. Constitution more than state constitutions? Why does the U.S. Constitution play such a large role now in constitutional law? Well, to make a long story short, Reconstruction happened. As hopefully some of you know, after the Civil War, there were all sorts of issues. The freedmen, the former slaves, turns out they weren't really free in a functional sense. There were all sorts of abuses, not just of the freedmen, but also the people who helped them. And when the freedmen and their white allies turned to the courts, they didn't get much protection. Those state constitutional provisions that I love, they were ignored by elected judges. When they turned to the federal courts, they didn't get any help there either. The U.S. Supreme Court, in a horrible case called Dred Scott, said that African Americans couldn't even be citizens. And so there was this problem where slavery had technically been abolished, but something that looked a lot like slavery from a functional standpoint still existed. And so that's why the 14th Amendment was ratified, and people started bringing lawsuits that traditionally have been brought under state constitutions in federal court under the 14th Amendment. That said that now everyone born here was a citizen. You could sue state and local governments in federal court. This was hugely important, right? Because federal judges aren't elected. When the federal judiciary was created, the framers understood that it was extremely important for judges to stand up for rights, even when it was unpopular to do so. And that, in fact, was the most important time to do it, was when it was unpopular to do so. There are also some key parts of the 14th Amendment that people rely on in federal cases today. The Privileges or Immunities Clause, the Due Process of Law Clause, the Equal Protection Clause. These are all great things, right? Privileges or immunities was supposed to do most of the heavy lifting and cover a lot of economic liberty concerns that I deal with today. Due process of law is a venerable concept that goes back to Magna Carta that says for a legislative act to really be a law, it has to have certain characteristics. It's not just procedural. And then, of course, equal protection. You can't treat similarly situated people differently. So then what happened? Like, why am I not just bringing all my cases in federal court today? Well, it reminds me of one of my favorite quotes of all time. When James Madison was presenting the first draft of the Bill of Rights to Congress, he explained how this Bill of Rights would be useful. He wasn't originally a fan of it, but they reached a deal. He presented it to Congress, and he explained, and these are James Madison words, that the Bill of Rights will be used by the judiciary to become, quote, an impenetrable bulwark against every assumption of power in the legislative or executive. And I love that quote, right? I love that. An impenetrable bulwark against every assumption of power. That's wonderful. If only that were true, but it's not. Federal judges are not impenetrable bulwarks. They're people. They make mistakes. Sometimes the government slips one by the goalie and government grows. And that's really the story of the 14th Amendment. The Privileges or Immunities Clause was immediately eviscerated by an opinion called the Slaughterhouse Cases that everyone agrees is wrong, but it's still good precedent, unfortunately. The progressive movement successfully disparaged the Due Process of Law Clause. They started calling it substantive due process, and the name stuck. Equal protection got watered down as well in most cases. And so the 14th Amendment, it's not what it was supposed to be. It was supposed to be a very useful tool against infringements on individual liberty. And now it's only really useful if your liberty being infringed happens to deal with one of the parts of the Constitution that the U.S. Supreme Court still cares about after the New Deal. And unfortunately, that's not a very long list. And so, after that happened, after in that mid 20th century, really, the 14th Amendment got watered down and constitutional protections at the federal level in general got watered down. People started bringing more state constitutional cases again. And so it's important to realize, when do I bring them in federal court? When do I bring them in state court? And you got to know the relationship between state and federal constitutions. And basically what it boils down to is, if it's a part of the U.S. Constitution that the Supreme Court still cares about, I'll bring it in federal court because my chances of winning are slightly higher with an unelected judge. But in most of my cases, there's useful stuff in state constitutions that gives me an advantage that I wouldn't have in federal court, so I bring it in state court. And when I bring those cases in state court, here's really kind of the basics that I have to remember. So first, in terms of the relationship between constitutions, a state constitution can never go below the federal national floor. So the US Constitution sets a minimum for protections of liberty, but state constitutions can go above that and have additional protections. Also, your state Supreme Court is the court of last resort when interpreting your state constitution. So again, as long as it doesn't go below the federal floor, your state Supreme Court can actually disagree with the US Supreme Court and say that an identical provision in your constitution provides more protection than the federal provision. And this happens quite a bit. State constitutions, pretty much all of them, have things not found in the US Constitution that are extremely useful and protective of individual liberty. And pretty much every state Supreme Court has some sort of precedent where it said, yeah, we see what the US Supreme Court said about this identical language that we have in our state constitution, but we disagree, we think it's more protected. And so whenever I'm going to bring a case, particularly an economic liberty case, I need to look both at the text of the Declaration of Rights in that state to see what useful tools we have that don't exist in the US Constitution. And I need to look at the state Supreme Court precedent, not just about those additional useful tools, but also I need to see if they've interpreted identical clauses differently, as they're allowed to do, to give me better precedent than I would have in federal court. And again, it's often the case. Almost all of my economic liberty cases are in state court under state constitutions, even for clauses that exist in every constitution, state or federal, like due process or equal protection. You're typically going to find precedent from the state Supreme Court that's more useful than the federal precedent. And then, of course, you have, again, the useful provisions not found in the federal Constitution that oftentimes that really dealt with economic liberty, things like anti-monopoly clauses or prohibitions on specific emoluments, which basically meant like a special privilege given to a group of people, things like that, that just don't exist at the same level. You might have some aspects of them in federal law or the federal Constitution, but just really, really useful provisions in state constitutions that I almost always find every time I'm looking into a case. And so I get to go to state court and win way more often than I would win in federal court. So let's apply these situations to Michelle's food truck, right? When we decided to take this case and I decided to represent Michelle, I noticed two glaring and wonderful things about North Carolina constitutional law that are all incorporated into the lawsuit I filed on her behalf. So the first is the North Carolina Declaration of Rights includes useful tools not found in the US Constitution. Now, again, most state constitutions have those types of useful tools, or at least some of them. Very few have as many of them as North Carolina does. And I'm going to go through a few of them in a second. So you just got a Declaration of Rights that's chock full of useful stuff, which is exciting to me as a constitutional litigator. And then second, even for the things that everyone has, like due process of law and equal protection, like many Supreme Courts, the North Carolina Supreme Court has created some precedent that's better than the federal precedent, that's better than the US Supreme Court precedent, saying in this state, under these provisions, you get a little bit more help, a little bit more protection than you would in federal court. And so when I brought the case on behalf of Michelle, we brought several different types of claims. We brought some claims based on the different things that only exist in the North Carolina Constitution, at least compared to the federal Constitution. And we brought due process and equal protection claims because even though those also exist in federal courts under the federal Constitution, your precedent's better than the federal precedent. So we might as well use that as well. And we just have to win on one of those claims to win. So here are some useful provisions in North Carolina's Declaration of Rights. If you read Article 1, you'll see all of these. Section 1, enjoyment of the fruits of their own labor. Like that's a really useful clause. And the North Carolina Supreme Court has talked about it, has explained that it can be its own cause of action, right? That you're allowed to enjoy the fruits of your own labor and the government cannot unreasonably restrict it. Section 19, the law of the land clause. I love seeing that one. That's something else that directly goes back to Magna Carta. In fact, due process of law was in large part, that concept based on the law of the land clause in the Magna Carta. And so even if due process of law has become distorted and watered down and incorrectly called substantive due process, well, clearly we know what law of the land is talking about. It's talking about what the Magna Carta was talking about. And so I love seeing that there too. Exclusives or separate emoluments. Again, that's all about giving special privileges to people, how that's not allowed. Well, that's what I fight against, right? Almost all of my cases involve the government saying, we like this group better than we like you. We're going to let them do something we're not letting you do. Like in Carolina Beach, they said, you can have a food truck. Food trucks are great as long as you own a restaurant. but not if you don't own a restaurant. And Section 34 in the North Carolina Constitution in Article 1, perpetuities and monopolies. Again, it's the same concept that the government can't create private monopolies for their friends, right? And I've had a bunch of cases about this. I actually won a case not that long ago in Little Rock on behalf of a taxi driver who was told he wasn't allowed to compete with Yellow Cab. Won that case in court under the Arkansas Anti-Monopoly Clause, which is verbatim identical to the North Carolina Anti-Monopoly Clause. And so these are useful provisions. I win in court on them all across the country when I find them. And if Carolina Beach had not thrown in the towel, I would have liked my chances fighting that case out too. But that's just the stuff in the text. Then we get to the precedent, right? And the precedent is awesome as well. I know most of you aren't lawyers. I'm not going to go through all the cases. I'm just going to talk about my personal favorite. My personal favorite North Carolina Supreme Court case is called King versus Town of Chapel Hill. It's from 2014, so relatively recent. And I love this case for three reasons. First, Chapel Hill loses, which is always a good thing. Go Wolfpack. But second, even setting aside my personal biases, the court explains that its test under the rational basis test, which is kind of the lowest standard of review for rights that the courts don't care about, like economic liberty and property rights, that even under that test, the North Carolina test is better than the federal test, that facts really matter, that evidence really matters. And so the business won. There was a towing business. I know they're not sympathetic, a tow truck business, but there were a bunch of unreasonable regulations on whether they could accept credit cards and charge credit card fees and things like that. And even with that unsympathetic plaintiff, the small business owner still won. And third, another great thing about this case is it talks about how under the North Carolina Constitution, the right to earn a livelihood is a fundamental right. And again, that's just huge, right? I mean, typically, if a court says that something is a fundamental right, that means you're going to have the highest standard of review. There's going to be a real burden placed on the government to justify these regulations, and it makes my life a lot easier. Now, the North Carolina Supreme Court in the Chapel Hill case didn't go as far as I would have liked to say, all right, now we're going to apply strict scrutiny, which is the hardest thing for the government to overcome. But just the fact that they would describe the right to earn a living as a fundamental right, like you would never see that in federal court. You would never see that from the U.S. Supreme Court. And it just gives me so much ammunition to build on it and so many tools to use to fight for people like Michelle. Listen, I always want what's best for my clients, but I almost wish that Carolina Beach had fought back, because just the precedent we could have created in that case would have been wonderful, because we could have built on this precedent, like in the town of Chapel Hill case where Chapel Hill got its butt kicked. All right. And so, so just wonderful things in North Carolina. We've got, you got great provisions in your Declaration of Rights, which you all need to read. You've got a great Supreme Court precedent, including pretty recent precedent, 2014 in the Chapel Hill case. And so I go into court, I've got all this precedent, I file this lawsuit, and Carolina Beach, they throw in the towel. Okay, because we've made the world a freer place. Michelle's operating in Carolina Beach today, as well as other towns. So are the other plaintiffs I've represented in that lawsuit. And that kind of leads me to one of the most satisfying parts of my job. As much as I love to sue the government, and I get a lot of joy out of making bureaucrats' lives miserable, and perhaps that's petty of me, but I do. Really, the best thing about it is when I get to make the world a little bit freer for small business owners like Michelle. And at IJ, we're such a well-funded, large organization that one of the cool things about IJ is they come up with these really great videos. And so what I'd like to do now is I'd like to show you a little video they made after Carolina Beach got rid of their food truck ban. If I can pull it up.
While the video is playing, we'll remind you that you are listening to Justin Pearson of the Institute for Justice, talking about the importance of state Supreme Courts and state constitutions. He's showing us a video related to the Carolina Beach case dealing with food trucks that he won on behalf of, you see her right there, Michelle Rock, Aaron and Monica Cannon, and Harley Bruce. Once again, this is a video from the Institute for Justice talking about the Carolina Beach case that our speaker Justin Pearson was involved with. Case didn't actually have to go to court to set a precedent, as he was telling us, because Carolina Beach, after the suit was filed, decided to step back, allow Justin and his client to win. Justin, very interesting video. We actually didn't hear the sound, so I was giving a little bit I was giving a little bit of narration of the fact that you were just describing this case.
Thank you. Hold on a second.
But now we're gonna turn it back to you for the remainder of your presentation.
Well, thank you so much, Mitch. I appreciate the narration. I don't know why the sound didn't play. I must have hit something wrong. But I apologize. But honestly, actually, if there were going to be a video where you didn't hear the sound, that was a good one, because it was really just background music. So thankfully I picked the right video to make a technical error about. But yeah, just turning back to my talk quickly. Let's see here. I just want to pull up one more thing. And in conclusion, I'd like to leave you with a couple points. And I know I've covered these all today, but just I can't stress it enough. I know I sound like a broken record, but please, if you care about freedom at all, if you care about constitutions at all, if you've read the U.S. Constitution, if you've read some of the Federalist Papers, and you're interested in this stuff, you have to read the Declaration of Rights. It's Article 1 of the North Carolina Constitution. You're going to love it. It's incredible. Honestly, it's better than the U.S. Constitution. It's better than the Bill of Rights. And because it has to be, right? It's not allowed to be worse than the Bill of Rights, but it can be better, and it is. It's not allowed to go below the national floor. It can go above it, and your state constitution certainly does, and kudos for that. Now, every state constitution is different, right? Different state constitutions have different protections. This is true both in terms of their plain language, the text of the Constitution, but also from the Supreme Court in the state and how they interpret it. And as I pointed out, both from a textual standpoint and a Supreme Court standpoint, the North Carolina Constitution is stronger than most. And so, you can honestly say, like, at least when it comes to the things that I fight about, economic liberty and regulation and protecting small business owners, if you're talking to someone from another state, there's a good chance you can honestly say that your state is freer than theirs. And it's because that both, the language of your Constitution and the precedent interpreting it is stronger than most places. So well done, North Carolina. You're a great state. You're also a pretty free state, and that's a wonderful thing. Thank you.
Thank you, Justin. And I'm going to have some questions for you. But first of all, I want to remind you that if you have questions for Justin Pearson of the Institute for Justice, please submit them via our Facebook page. And Justin, before I get to my questions, I do have a couple of, one is a comment and one is a question. First, the comment comes from one of my colleagues, Brene, in this office, who, like me, is a graduate of the University of North Carolina at Chapel Hill, who says, "How dare you go Heels?" So take that to heart. We also have a question from Kenneth, who asks, "Are there cases where a state constitution conflicts with the federal constitution?" He doesn't ask this, but I think the follow-up would probably be from Kenneth, well, what happens if there's a conflict? What happens?
Yeah, that's a great question, and I'm going to talk about that in a second. It's just a wonderful question. I do want to say thanks for the questions. I realized I was probably talking pretty fast, since that took about 5 minutes less to present than I anticipated. So hopefully you could all keep up and I wasn't talking too fast. But anyway, to answer that question, right, so the state constitution can go above the federal floor, but it can never conflict with it by going below the federal floor. And we actually had a case about that at the U.S. Supreme Court at IJ. There was a school choice case only about a year ago called Espinoza, where state constitutions, like 36 of them, had these horrible things called Blaine amendments that arose out of anti-Catholic bigotry, in the late 19th century, and were being used by teachers' union to prevent school choice programs. And so we represented a group of students and their parents who wanted to, in that case, it was North Dakota, take advantage of student school choice programs, even though the state constitutional Blaine amendment had been interpreted by the state Supreme Court to block them. And so we brought the case to the U.S. Supreme Court, and the U.S. Supreme Court took the case, which is amazing in and of its own right, because the U.S. Supreme Court only grants about 1% of the cert petitions that are filed. Like 99% of them, you're just stuck with whatever the lower court said. But the U.S. Supreme Court took the case. It agreed with us that those anti-Catholic Blaine amendments violated the First Amendment, the Establishment Clause of the First Amendment of the U.S. Constitution, and so consequently, that those Blaine amendments were ruled unconstitutional. And so again, it just goes back to the fact that your state constitution can do things, above and beyond what the U.S. Constitution does, but it can never go below it. It can never violate the U.S. Constitution. If it does, the U.S. Constitution prevails, because in that type of conflict, the federal Constitution and the federal government is supreme, and because of the supremacy clause, it wins. And so that's just one of the wonderful things about state constitutions. I mean, honestly, if state judges were all unelected the way federal judges were, I might bring all my cases under state constitutions when you think about it, right? Because a state constitution can never be worse, can never be less protective of you than the federal constitution. And if it is, and if it does, like, all those states that had Blaine amendments, North Carolina wasn't one. So again, kudos to North Carolina. You guys are just crushing it. The U.S. Supreme Court can say, hey, this violates, even though it's in your state constitution, this violates the U.S. Constitution. Therefore, your state constitution is itself unconstitutional in this one regard. Great question.
You mentioned during the course of your presentation that every state has its own constitution and that they all have some differences from the federal Constitution. Does every state have an equivalent to North Carolina's Declaration of Rights, even the ones that came about after the Constitution, the U.S. Constitution? And if so, are those declarations similar to the older states like North Carolina, or do they differ?
So another great question. So the first part is yes, every state has some sort of Declaration of Rights. Some of them call them Bill of Rights. Most of them call them Declarations of Rights, like North Carolina does. And after the original 13, even with some of the original 13, you see a lot of copying, right? Government officials, they love to take what another government official has done and kind of do the same thing. And that's true when it comes to state constitutions as well. You'll also see a lot of copying among groups that are near each other geographically. So if one state out west has a certain clause, then the other states out west will probably have it. So yeah, there's a lot of copying, and a lot of great provisions will then find themselves in subsequent constitutions that came about when subsequent states entered the Union. But the real key difference is, and why some states that have great declarations of rights don't enjoy the same level of freedom, perhaps especially freedom from regulation that maybe North Carolina enjoys, is because the state Supreme Court won't enforce it the same way. And this is something that's really just a troubling pet peeve of mine. Back in the New Deal, the U.S. Supreme Court decided that there were some parts of the Constitution that it was going to kind of treat as second-class rights, and these included economic liberty and property rights and so-called non-fundamental rights that wouldn't receive the same level of judicial review as things like free speech. Now, that's not the way the Constitution is supposed to work. But even if you assume that if something's unenumerated or described kind of differently than the fundamental rights, that it somehow should result in lower protection, well, oftentimes these state constitutions would actually have enumerated express protections. And so you would think, well, at least as a matter of state constitutional law, you'd still get strict scrutiny, the highest level of review. But what we've seen in some states like, California or Oregon or whatever, is what they did is after the New Deal, they took that bad precedent from the U.S. Supreme Court about so-called non-fundamental rights, and they applied it to even stuff that was expressly enumerated in their own state constitution, just not enumerated in the U.S. Constitution. And so just from a logical standpoint, it made zero sense. And so that's why, unfortunately, it can be so frustrating where I'll come across a state protection in a state, not usually North Carolina, but some other state, where I get all excited and then I go and I read the precedent and it's been eviscerated by the state Supreme Court. It's just so important to have judges and justices that respect the Constitution, respect the original public meaning of the parts of the Constitution. Don't try to change it to what they wish it was, or try to view it as some sort of obstacle where it's a test of creativity to be avoided, but actually be faithful to the original understanding of the Constitution. Because if so, right, every state would have these wonderful protections that I could use, but instead what ends up happening is the states that need it the most, that have the most overregulation, that have just the worst climates for business, the worst climates for individual liberty. They also happen to be the ones where the state constitution doesn't care, or the state Supreme Court doesn't care about the state constitution the way that some courts might. And it's really, really frustrating, and it's difficult to see. But unfortunately, at the end of the day, you need real judges who care about first principles, and that's not always true.
That is Justin Pearson. He is a senior attorney and actually runs the Florida office for the Institute for Justice, argues constitutional cases, including state constitutional cases at a number of venues. I'm Mitch Kokai, sitting in for Donna Martinez, and we're going to continue our conversation through the course of the hour, but want to remind you that if you have questions for Justin about state constitutions and state Supreme Courts, feel free to submit them through our Facebook page. You can find it at facebook.com/John Locke Foundation. That's all one word, no hyphens, no capitalization needed. We'll take your questions if you have them. Justin, I'm going to put you on the spot just a bit because you've been saying nice things about the North Carolina Constitution and its protections. Given the states that you've worked in, how do we stack up? Are there other states that have constitutions that are better for people in terms of economic liberty? Or are we up there near the top? Are there some states that you work in where you just say, oh, this is going to be a mountain because I'm not getting help from either the Constitution or the courts?
Yeah, it really is. And again, I should focus on what I know about, which is economic liberty. Obviously, there are all sorts of constitutional issues out there, and I'm not going to try to talk about the ones that I don't personally encounter. But when it comes to economic liberty, yeah, North Carolina's Constitution and the precedent applying it is really near the top. I mean, there are other good states. I live in Florida, where we have some incredible state Supreme Court precedent, particularly saying that protectionism is never okay, that I've used to win cases in court on behalf of food trucks down here. I mentioned before, I won a case in Little Rock using the Arkansas Constitution's anti-monopoly clause, where I won that case in court, saying that what Little Rock did was unconstitutional. But even then, the clause that North Carolina has, where it's literally identical to the one I used to win in Arkansas. And so without kind of doing a real deep dive, comprehensive study, I can't name off the top of my head a state that has better state constitutional provisions and better state Supreme Court precedent than North Carolina. Now, it's all relative, right? The sad truth is that, as I mentioned before, many state Supreme Courts started watering down their own state constitutional precedent after what the U.S. Supreme Court did in the period near the end of the New Deal. And so many of these wonderful provisions aren't given the force that they should have. And that's happened in North Carolina to some degree, just like it's happened everywhere else. But it certainly happened in some places worse than others. Like, I mean, if I'm bringing a case in Oregon, which I did at one point, I had a case in Portland involving sedan drivers, like limo drivers. We brought the case in federal court. There was no advantage to bringing it in state court. There just wasn't. We've had cases in California. Typically, those are brought in federal court because, again, the state Supreme Court, no offense to them, I have respect for all judges if any of them are watching. But just based on what the precedent says, we knew we weren't better off under the state constitution and the state precedent, so we might as well bring it in federal court, where maybe judges are a little bit more willing to rule something unconstitutional. And so you really have to look state by state and state Supreme Court precedent by state Supreme Court precedent. And when you do, again, without kind of actually going through it systematically, just based on my own cases and what I've seen and what I've come across, North Carolina might be near the very top. It's relative. I mean, maybe it's, it says as much about how the other states have watered down their precedent as it does about how North Carolina hasn't, because you have as well, just not as much. But there's a reason why IJ's brought a few North Carolina cases over the years and probably will continue to do so. There are some useful provisions that don't exist in many other places.
It's a very important point that you're making, that it's not just what the state constitution says, but how the judges on the highest courts review this. Can you point to a particular state that has very similar protections within the written document to North Carolina, but because of precedent, there's just nowhere near the same level of protection?
Yeah. I mean, well, there was an anti-monopoly clause case brought in Georgia not that long ago. It wasn't brought by IJ, and so I'm not going to name the group that brought it since they lost, but they lost. And so I think it really does show you that it depends on what the precedent says. And there, the Georgia Supreme Court precedent that existed before that case was brought wasn't nearly as strong as the precedent we would have in North Carolina or that I had to use in Arkansas. And so even in states that you kind of group together regionally, the precedent will vary from state to state. And again, basically the whole Pacific Northwest is a lost cause.
I'm going to continue my questioning of Justin, but just a reminder, if you have questions, I'd love to pass along your questions. And Justin told me before we actually started this that one of the parts of the presentations he likes the most is getting to audience questions. So feel free to submit them via the Facebook page. That's Facebook facebook.com/John Locke Foundation, or even if you are like Brene and want to criticize him for the Wolfpack comment against Carolina, I'm sure he would be fine with that as well.
It's all in good fun. And I tell you, even among my colleagues at IJ, we've got a couple of UNC law school graduates, although one of them went to NC State. He's not too bad. We have a Duke Law School graduate, and so of course there's a lot of good-natured ribbing, but we're all fighting the good fight. And I know all of the people watching and affiliated with the John Locke Foundation value freedom the way I do. So it's all in good fun, regardless of school. Nobody's perfect.
I want to get back to what you talked about in terms of several provisions within the Declaration of Rights in the North Carolina Constitution, which is, as you said, Article 1, Section 1. Doesn't take all that long to read. You can contact the John Locke Foundation if you want to find out about getting a copy of the North Carolina Constitution. It fits a small book like this big. Nice to have with you. But you pointed to several of the provisions. One of them is one that I like to see a lot, and that is one that is right there in Section 1 saying that you have the right to the fruits of your own labor. How does that play out in the cases that you bring up?
Yeah, so it was something that we relied on in the lawsuit we filed in the Carolina Beach case. We didn't get to argue it, right, because Carolina Beach threw in the towel. But it's something that's really exciting, and I think it's kind of emblematic of this reinterest and rebirth of state constitutional law that we've had over the last few decades, where there actually wasn't a whole lot of precedent about that particular provision. I know because I researched it before we filed the lawsuit. But just in the last, say, 5 years, there have been North Carolina Supreme Court cases talking about that provision. In fact, including a case saying how you could bring it as its own separate cause of action, like it could be its own independent way of winning a case. And so, really what happened is, with the passage of the 14th Amendment, state constitutional law kind of fell by the wayside for like half a century. And then after the 14th Amendment was eviscerated, over the first half of the 20th century, state constitutional law kind of started coming back into the forefront, but very, very gradually. And just in very recent years, it's like people will just rediscover things that have been staring them in the face the whole time, written in plain language in their state constitution, but lawyers just hadn't been using because they didn't research their state constitution or read their state constitution. And I think that the fruits of their own labor clause is one of those provisions where, anyone who does constitutional law for a living, when you read that, you're like, oh, that's interesting. And yet there was so little precedent on it until just recently. Now all of a sudden everyone seems to be using it again. And it's kind of neat how that works. Hopefully that precedent will continue to grow and it will turn into an even more useful tool.
I have another question from Kenneth, and I'm going to get to that in just a moment. But first, sticking with the items that you highlighted from the Declaration of Rights, this is one that perhaps could use a little bit more explanation for non-lawyers like me, and that is the law of the land clause. Tell us a little bit more about what that means. You mentioned that this dates back to the days of Magna Carta, but if someone is saying that they're going to be making a claim based on the law of the land, how is that helpful for economic liberty?
Right. So the law of the land clause in Magna Carta was really like the forefather of the due process of law clauses that we're more familiar with today. And what it basically meant was that there are certain characteristics that would be required before a government action or legislative enactment could be considered a law, right? There are certain, for example, it can't be arbitrary. It can't be disrespectful of national rights. It also has to have process, right? You have to be able to go to court and vindicate those rights. But it wasn't just about process. It was this idea that just because the legislature did something, that doesn't really mean it's a law. That's actually even kind of a viewpoint we'll see in U.S. courts and like U.S. Supreme Court cases, like in cases like Calder versus Bull for the lawyers out there, where you'll really for the first 100, 150 years of the U.S. Existence as a nation, you'll see U.S. Supreme Court cases talking about how there's a difference between a legislative act and a law, and that a legislative act that violates certain principles as enshrined in the Constitution can't be called a law. And that's really what the law of the land provision in Magna Carta was about. It was that it's not just enough for the government to do something or to say they're doing it for a legitimate reason. It has to actually be for a legitimate reason. It can't be arbitrary, it can't be unreasonable, it can't violate your natural rights. There's got to be a process to vindicate it. It's got to have all those characteristics. And if it's missing any of them, then it's just a government action or legislative action. It's not actually a law. And so that's just a crucial point, right? That this was well understood at the time of the founding. right? And the founders, when they were drafting both the state constitutions that predated the U.S. Constitution and the U.S. Constitution, they were coming from a background of freedom, understanding that freedom was supposed to be the default, that just because the government does something, that doesn't make it right, that doesn't make it okay. And the law of the land provision from Magna Carta and then its subsequent iterations and due process of law clauses, that was really a key piece of kind of where they were coming from, this idea that you should be skeptical, you should have healthy distrust of your government, and there are all sorts of things the government can do that would then make what they were doing unconstitutional.
Back now to the question from Kenneth, who asks, do any of the state constitutions prohibit the abuses of defendants as we have seen with Title IX? Any thoughts about that?
I don't litigate Title IX. And the key about both state constitutional law and U.S. constitutional law is there are restrictions on the government. There are some rare exceptions, like obviously the 13th Amendment getting rid of slavery isn't just a restriction on the government. But for the most part, historically, both state and federal constitutions were just restrictions on the government, not on private parties, right? And so, I suppose in situations where the government is a defendant in a Title IX case, perhaps there could be some constitutional implications there. But it's not my area of law, so I really can't say.
All right, well, we can research that issue and perhaps can find some information. Kenneth, thank you for the question. And if you have more, we still have a little bit more time. Since we do have a few minutes to go, we referenced during the opening of your presentation that you dealt with this case dealing with the food trucks in Carolina Beach, but also mentioned the case of the makeup artist in Charlotte. Can you give us a brief synopsis of that case and how that moved forward?
Yeah, and I really should. Thank you for bringing it up, because it's an interesting contrast between what the cases I bring in federal court and the cases I bring in state court. Because my client there, Yasna, she was a small business owner who was dealing with overregulation in many analogous ways to the case I brought in Carolina Beach. The big difference there, though, was her business involved speaking, right? She wanted to tell people how to creatively and artistically present makeup. And because her business involved speaking and was primarily about speaking as opposed to cooking food for someone, it falls within the First Amendment, which it turns out is one of the parts of the U.S. Constitution that the Supreme Court really cares about. And so we brought that case in federal court instead of state court. And that's really the only difference, right? If Yasna were doing something that didn't involve communication, we would have brought it in state court the same way we brought the Carolina Beach case in state court. And if the Carolina Beach food trucks just wanted to talk to people about food instead of serve them food, we would have brought their case in federal court under the First Amendment instead of in state court under the state constitution. But because Yasna her business was about talking, and Michelle in Carolina Beach, her business was about actually serving food, we brought the first in federal court, the second in state court. Both times, though, the government ultimately threw in the towel. The case on behalf of Yasna, who lives near Charlotte, I was against the state of North Carolina for their licensing requirement, basically restricting who was allowed to teach makeup. And the state of North Carolina, to its credit, about, I think, 6 months after we filed that lawsuit, threw in the towel. And so now Yasna can talk about makeup again. But yeah, it was a First Amendment case just because it involved speech, and that's one of the parts of the Constitution that the U.S. Supreme Court still has good precedent about.
Both of the examples that we've talked about have dealt with cases in which the defendant eventually threw in the towel. How often do you find that that's true, that not just in North Carolina, but in other places where you're working, that just bringing the suit, telling the government, hey, you're not supposed to be able to do this, is enough to actually get the proper result?
Yeah, and we don't have unlimited resources, so it does matter to us. Like there are times where we'll send letters to government officials saying, hey, maybe you don't realize this, but you're violating the Constitution, you should fix it. And then there are other times where it's clear that a government official has no interest in following the Constitution. The people we end up representing actually told them, hey, you did this, violates the Constitution, this violates my rights, these are things you've done wrong, and they just basically don't care. So those are the cases we bring. But even then, even in those situations where the city official has been warned either by us or by the person we represent, and the city official clearly just could not care less about the Constitution, once we actually show up and file a lawsuit, it's amazing how often their tone changes and how often they just throw in the towel to make the issue go away. It's such a shame. Your constitutional rights and your ability to be protected by those rights shouldn't turn on whether you win the lottery of having a free public interest lawyer like me take your case. But they often do in practice, right? I mean, we're extremely well funded, but we don't have unlimited resources. We only take a small percentage of the cases that are referred to us. If we take your case, you're probably going to win one way or the other. If we don't, you probably won't. And that's really not the way things are supposed to work. I'm glad we win the ones we do and we bring as many as we do, but it's really heartbreaking that we can't bring more, because it's just frustrating that so many people can't get their constitutional rights vindicated because they don't have a free lawyer who knows about constitutional rights to stand up for them. And just to kind of go back to your original question, it's like probably about half the time. About half the time after we followed a lawsuit, even after all those original steps were taken, that then now that we've actually filed a lawsuit, and perhaps the official who didn't care about the Constitution before has talked to a lawyer and realized that they're about to lose in an embarrassing way, they throw in the towel. And that's great. It's great for our clients, and we love it when the government does the right thing, even if they do it belatedly. But in terms of the impact for the public, in many ways, it's actually a blessing in disguise if the government fights back, because then we get to create precedent that helps out everyone. And so, again, I'm very happy for Yasna, the makeup artistry teacher in Charlotte, and for Michelle, the food truck owner in Carolina Beach. And it's wonderful that the government in both cases, the city government and state government, came to their senses. But if they had actually fought back, we would have created some powerful precedent. I think likely would have created some powerful precedent to help out everyone. Thankfully, North Carolina already has some good precedents. Even without our precedent, you're still in good shape.
Well, excellent cases, and we're glad for your clients that you did not have to go to trial on either case. I want to switch gears slightly, but it actually returns to something that you mentioned earlier, and that is, I know that it's the Institute for Justice doesn't get involved in elections, doesn't tell people who to vote for, how to vote, doesn't play any role there. But you did make an important point that it's important to have a good state constitution that has constitutional protections. It's also important to have people as judges or justices interpreting these constitutions who basically follow common understandings of what things in the Constitution mean. So an important part of the equation, I'm sure you would agree, is who sits on these courts and what they think about the Constitution.
Sure. No, that's absolutely true. And again, yeah, I'm not ever going to talk about any specific election or anything like that. But one of the things we do talk a lot about at IJ is this idea of judicial engagement. You need an engaged judge who cares about the facts, who cares about what's really going on, who's not just going to take things that government officials say at face value. In fact, one of my former colleagues, Clark Neely, who's now at Cato but used to work with me at IJ, wrote a book that he literally titled "Terms of Engagement" about the role of judges, in applying the Constitution. So if any of the viewers are really interested in this subject, I would highly recommend his book. It's excellent. Again, it's called Terms of Engagement. But yeah, I mean, without getting into any specifics about any particular judges or courts, we need engaged judging. We need judges who are willing to actually look at the Constitution and apply it faithfully. And sadly, that's not always true. I think sometimes judges and government lawyers, for that matter, they kind of view constitutions as a test of their creativity instead of something to faithfully follow. And that's not the way things are supposed to work. You're supposed to actually try to follow the Constitution, not see if there's a way to get around it.
Thank you for giving me the chance to plug CarolinaJournal.com, because if you go to CarolinaJournal.com and search for Clark Neely's name, Clark, and then the last name is Neily, I believe just one L, in Clark's last name, I think, maybe two L's.
I should know. I thought two, but I could be wrong.
Yeah, maybe at Neily or Neilly. You can search our website and find the presentation when he spoke about terms of engagement to a John Locke Foundation audience. We also interviewed him for the Carolina Journal website. You can find that. This is now an opportunity. If you do have a pressing question, get it in now, because we only have a few minutes left. But we do have one more that's on the page from Tom, who says, if I understand the reply, your reply regarding speech, First Amendment, a contractor is delivering something tangible. Therefore, issues in this trade do not fall under the First Amendment? That makes sense?
Right. So yeah, so something really weird happened during the New Deal. And basically, Tom, you kind of understand, as crazy as it sounds. So let me kind of flesh it out a little bit more. Basically, during the New Deal, as hopefully many of you know, there was kind of this standoff, I'm oversimplifying, between FDR and the U.S. Supreme Court, where FDR was mad that some of his programs were being ruled unconstitutional. There was basically, he threatened court packing, an issue that now, surprisingly, we're hearing about a little bit more in the news these days, in terms of the U.S. Supreme Court. And afterwards, the U.S. Supreme Court kind of changed its approach and started upholding more of FDR's programs than they had in the past. Now, there are all sorts of theories why they did this. Some say, well, obviously it was because of the threats of court packing. Other people say there are other reasons. Some people think it was because of the landslide election in 1936, and the court just got fed up being so unpopular. For whatever reason, after 1936, the U.S. Supreme Court started treating the federal Constitution as if it were really like two different classes of rights. It used to be that all rights mattered and all rights were kind of treated with the same level of respect. But after the New Deal, starting late in the New Deal, after the switch in time that saved nine, as it's called, basically this U.S. Supreme Court said the rights that we really care about, they're going to be called fundamental, and they're still going to receive meaningful judicial review where the burden's on the government. It's called strict scrutiny. The other rights that we no longer care about because we shredded those parts of the Constitution to uphold FDR's programs, we're going to call those parts of the Constitution non-fundamental. And those are going to receive something called the rational basis test, which is supposed to be kind of the easiest test ever for the government to meet. And so now much of constitutional law in practice as a litigator involves arguing over which type of right you're talking about, whether it's a type of right that gets meaningful review where the burden's on the government, or the type of right where the burden is not on the government and you have absolutely every possible burden to negate every conceivable rationale for the law, which is what happens in the economic liberty cases. And so, yeah, it just leads to this weird situation where, because Yasno was talking, well, that's part of the Constitution that the U.S. Supreme Court never shredded. So we get to win that case in federal court, or we would have if the government hadn't thrown in the towel. But Michelle just wanted to cook food, not talk about it. So we had to bring that case in state court or in the state constitution, and she still won. But even despite all of the wonderful things about the state constitution that I talked about in the state Supreme Court precedent, that case would have been harder to win than Yasna's case in federal court under the First Amendment. And that's not the way things are supposed to work, right? Constitutional law shouldn't be this big fight over whether something's speech or conduct. Like, that's not what the framers envisioned. That's not what the people ratifying either your state or federal constitution envisioned. But that's kind of what constitutional law has devolved into. And it all goes back to I would call it, intellectually dishonest approach taken at the end of the New Deal with the switch in time to save nine that kind of turned the Constitution in these two separate parts. And it's not the way constitutional law is supposed to work.
Well, great questions from the audience. We thank you for submitting them, and we hope that you'll tell your friends to watch this presentation. If they missed it live, they can watch it on the Facebook page, on the YouTube channel, also from the John Locke Foundation's johnlocke.org website. In the time that we have remaining, Justin, would you like to recap? I think you had a homework assignment for people that should read Article 1.
Yes, please. If you do nothing else, if you forget about me 10 minutes from now, just read your Declaration of Rights. It's Article 1 of the North Carolina Constitution. And I should also add, I think I'm actually required to say, if you're interested in anything I talked about, please go to our website, ij.org. It's super justice. It's a very simple website, ij.org. There's stuff about every case I talked about today and every other case we've ever done. It's a wonderful website. But yeah, even if you never go to my website, ij.org, if you just read your state Declaration of Rights at the very beginning of your state constitution, again, anyone who's interested enough to watch my talk is going to love their Declaration of Rights. So I highly recommend you do that one thing.
Yeah, ij.org, a very valuable website. Justin Pearson is the Florida office managing attorney for IJ, and as he explained, worked on a couple of very interesting North Carolina cases. Justin, thanks so much for taking the time today.
Thanks, Mitch. As I've told you before, I've actually watched quite a few John Locke Foundation videos online. You guys do great work, and it's an honor to be here.
Well, thanks so much, and we thank you for joining us for this presentation. If you like these presentations and would like to see them continue, of course, one of the things that we always ask is that you support the John Locke Foundation. You can go to johnlocke.org and search for the donate button to find out how you can support events like this one and the other work of the John Locke Foundation. Donna Martinez will be back in action next week, and we hope that you will join her for another very interesting presentation. My name is Mitch Kokai. Thanks once again for joining us for the Shaftesbury Society.